Moving on to the civil rights cases in 1883, we witness that Congress has taken the decision of the slaughterhouse cases, listened to the court, and decided to legislate in a particularized area. So pursuant to the claim that the civil rights amendments can be enforced through appropriate legislation through Congress, Congress moves ahead and in 1875 passes a Civil Rights Act. Um, the Civil Rights Act of 1875 does a number of things, but primary focus for us in this case is it bars racial discrimination in terms of public accommodation. Um, this is us coming back to the idea of public accommodation. So this banned racial discrimination in terms of any form of public accommodation, travel, lodging, eating, anything that is largely considered a public accommodation, the Civil Rights Act of 1875 prohibited. And they prohibited based upon their authority in the 14th Amendment. So Congress uses the 14th Amendment, which seemingly empowers Congress to attempt to eliminate discrimination, and they do so. But what the Civil Rights Act of 1875 does is it doesn't just touch upon state power, it also touches upon private entities. And so the legislation is fairly broad here. Um, Justice Bradley writes the majority opinion. And the issue in this case is, does the 14th Amendment empower Congress to be able to regulate public accommodations for purposes of discrimination? And the answer the court says pretty clearly is that no. The 14th Amendment exists, according to Justice Bradley, to remedy state action. That the reason why the 13th, 14th, and 15th Amendment were passed was to stop violations of the states against the rights of individuals, primarily freed slaves. But what it didn't do was make it so that Congress could target discrimination between private entities, between private parties. Congress absolutely can reach the states and state action. So when the state itself does something, Congress can reach that. But the 14th Amendment does not empower Congress to reach private actors who do something. The majority hints at something that we'll absolutely come back to. The majority says that the 14th Amendment doesn't get Congress there, because very clearly in terms of reasoning that these amendments were passed to stop states from passing laws and enforcing laws that were discriminatory on the basis of race. But the intention of the individuals who drafted the 13th, 14th, and 15th Amendment, and really the only one that applies here is the 14th, because the 13th and the 15th are very clearly pointed at state action. So slavery is abolished, that's state action. The 15th Amendment, African Americans have the right to vote, that's state action. The 14th Amendment is a bit more amorphous in terms of language, but the court says that the 14th Amendment targets state action only. But Justice Bradley hints at, even though the 14th Amendment doesn't get Congress there, Congress might be able to get there another way. So if Congress wanted to pass the Civil Rights Act of, let's say, 1884, the year after this case was decided, and they hinged that Civil Rights Act, which doesn't exist, on the Interstate Commerce Clause, which allows Congress to regulate areas in which there are interstate commerce concerns, that you might actually be able to reach private action there, because public accommodations are providing goods and services. It is not outside of the realm of imagination to see individuals travel across state boundaries for reasons of lodging, or travel across state boundaries for regions of commerce, or travel across state boundaries for reasons of consumption, getting food or farmer, anything that a public accommodation applies, one could imagine a reality, because it's not very hard for us who live here in El Paso, to imagine that it might be, we might want to travel to New Mexico 5 minutes away to do something as opposed to doing it in Texas. And that act is interstate commerce, and Congress can regulate it. So while the majority opinion in the 8-1 decision written by Justice Bradley says that the 14th Amendment doesn't get there, they sort of hint that the Interstate Commerce Clause might actually get you there. So if you wanted to pass a very similar law with using the Interstate Commerce Clause powers, Congress might be able to do so. Before I move on to the Senate, I'll tell you that Congress doesn't do so. They don't do so for a very long period of time. In fact, it isn't until the Civil Rights Act of 1964 where Congress does use its commerce powers to actually regulate public accommodations. So it takes over 70 years for Congress to take the advice of this court and actually pass a law to regulate public accommodations for purpose of discrimination based upon their interstate commerce powers. So the 14th Amendment doesn't get there. The Congress's commerce powers might actually get there, but Congress doesn't try to get there for any time in the near future. There is a dissent in this case, and that dissent comes from Justice Harlan. Justice Harlan is the lone dissent in this case. This isn't the only case Justice Harlan will be the dissent in. He'll be the dissent in the next case we do too. But in this case, in the civil rights case, Justice Harlan argues that the Civil War amendments do one thing. They bar discrimination against African Americans in any state if the same protection is afforded whites. That's what the Civil War amendments do. And state action is a legal distinction, and legal distinctions are not mandated by the Civil War amendments. There's a reason why the language of the 14th Amendment is broader and doesn't reference state action. They could have, but they didn't. And the language is broad, and concepts of equal protection, concepts of privileges and immunities don't have to just apply to state action. They can apply broader. And if the individuals who ratified the 14th Amendment had intended to solely target state action, they would have said so, but they didn't. And therefore, we would have to take the amendment as it's written, and since Congress is empowered to regulate in these areas, Justice Harlan in dissent would say that the Civil Rights Act, as passed in 1875, is constitutional. But in an 8-1 decision, Justice Harlan loses. And so the law really to this day is that the 14th Amendment prohibits state-based discrimination, and Congress can reach in and regulate the states, but the 14th Amendment doesn't allow Congress to regulate private interaction.